We do these orders to file special reports pretty frequently. For example, every year we issue an order like this to tobacco companies on to get information about their advertising spend. Here what we're doing is issuing this order to a relatively diverse array of companies. They cover a lot of ground. Companies, like YouTube and Facebook and Reddit. I think that we're trying to gather information about how these companies collect, use, share data, the kinds of choices they offer. How do they determine which ads to serve up? How do they determine which content to serve up? How do they use algorithms and data analytics, and how do they apply those to personal information? How do they measure, promote, research, user engagement? And how do all of these practices affect kids and teenagers?
Yeah, I think there are many people who would be interested in learning many of those things you just mentioned. What has the response been like in the past, given you've issued orders in some ways that are similar? Do the companies typically cooperate? Is there a transparency or a lack thereof, perhaps, that still allows many of us to be in the dark on exactly what is truly being collected?
Well, this is compulsory process. Companies are required to respond, and if they don't, then we go to court and we get a court order requiring them to respond. And if they don't, again, then they're in contempt of that order. So this is relatively well-trodden ground. This is authority the commission has had for more than 100 years, and we take these orders seriously. So we do expect full compliance. We expect prompt compliance. I anticipate there's a lot of information that we're asking for, so I anticipate that it will take a little bit of time for the companies to gather this information. But to give you an example of the timing on this in the past, in 2012, we did orders like this to a series of data brokers. And then subsequently in 2014, we issued a report on that. So this is a process that might take a couple of years to play out, and there might be a number of different deliverables that result from this information gathering.
Right, Andrew, let's talk about some of those deliverables. Past FTC privacy settlements have been criticized as being toothless. Fines even in the billions of dollars for Facebook and Google, they've been easily absorbed by these companies. So what have you learned from those settlements, and what would you do differently, if anything, next time around? Would you try to implement more structural changes at these companies?
So I don't agree that the orders that we obtain are toothless. The monetary remedy is a part of the order, but those aren't the only teeth. And in some ways, it's the injunction that we obtain against the company that's more meaningful. So with a case like the order that we got against YouTube or the order against Facebook, we have detailed requirements placed on the company, placed on its board of directors, for changes in the way that the company fundamentally does business. So, for example, with Facebook, any change to the service, they have to conduct a privacy impact assessment and get sign-off from executives who are high up in the company. So, this order obviously is still playing out, but what we understand from public information that Facebook has made available is that this is a significant undertaking for the company, and that these privacy impact assessments really do affect the way that the company does business, and really do make them put privacy on the top of the list of priorities when developing new services for consumers.
Shepard Smith here. Thanks for watching CNBC on YouTube.